started at this point. Noticing from the registrants on this, a lot of you are bankruptcy practitioners, either attorneys or financial advisors. And I think by virtue of the fact that you're interested in participating today, you have a general background, and perhaps much more than a general background on bankruptcy sales. But for the benefit of those of you that are maybe not as familiar as others with the bankruptcy sale process, I will be spending a little bit of time on a general discussion of sales and bankruptcies, what the benefits of proceeding through a sale in a bankruptcy as opposed to outside of bankruptcy are, and a somewhat truncated version of going through the process and procedures of a sale and how that can be accomplished in bankruptcy. Then we'll turn to a discussion of successor liability under non-bankruptcy law, because without that, we don't really have a concern in bankruptcy law. So we will go through some of the concepts of successor liability that have been imposed under non-bankruptcy law, and given the fact that most of us here on this webinar are in California, I'll be focusing on California law. So you'll find that the concepts of successor liability are fairly uniform throughout the United States, although I'll profess to you that I haven't done a broad review of every jurisdiction throughout the United States to confirm that they are similar. But from the cases I have reviewed, you have very similar concepts throughout the United States. After discussing the general concept of successor liability under non-bankruptcy law, we then turn to the scope of a Section 363 order and its impact on potential successor liability claims against the purchaser of the assets. And really, throughout this presentation, I'll be looking at the issues from the lens of a buyer of assets as opposed to a seller or a claimant or a potential claimant, because I think that's the most important thing at the end of the day. From the seller's perspective, the seller in a bankruptcy case usually doesn't care what happens afterwards. It's the buyer that cares, so that's the lens that we're looking at, or through which we're looking at. Then we'll go through some of the limitations on the protections that can be afforded under a Section 363 sale order, including limitations on potential unknown tort claimants and environmental liability. And finally, we'll close with a discussion of some practice tips that you can employ while you're representing a prospective purchaser of assets through a bankruptcy case. And I would spend some time, perhaps a little bit of time, on an example of a very well-written and very broad sale order that provides some exculpation for almost every kind of claim we can imagine. So once we're decided that we're going to be dealing with a bankruptcy sale, there's really two avenues to effectuate a sale of assets in bankruptcy. If you're dealing with a bankrupt debtor that's in a Chapter 7 liquidation, there really is only one way, and that is through a sale approved by the court pursuant to Section 363 of the Bankruptcy Code. On the other hand, if the debtor is a Chapter 11 debtor going through a reorganization, the sale can be accomplished in two ways. One, by motion through 363, just as you would be in a Chapter 7 case, and the other would be through and as part of a plan of reorganization. Section 363, which is the basis and the statutory predicate for allowing a sale to go forward in bankruptcy, provides that a trustee, and I have in brackets, or a debtor in possession, because in Chapter 11, it's commonly held that the debtor in possession and trustee are interchangeable for most purposes regarding the administration of the case. While a debtor remains in possession, he acts as the trustee, or it acts as the trustee. Provides that the 363 says that after notice in a hearing, the trustee or the debtor in possession may sell, other than in the ordinary course of business, its property of the bankruptcy estate. And in order to do so, there has to be notice to creditors, and you need to obtain court approval, whether that's affirmative or based on lack of objection from creditors. Now, the distinction that's drawn between ordinary course, a sale in the ordinary course or out of the ordinary course, is important here. It's a distinction that dictates whether court approval is required. And just as an example, if your debtor is a seller of used cars, it wouldn't need court authority to sell a Ford Explorer that's sitting on its lot, because that's the ordinary course of its business. On the flip side, if it decided that it was going to sell all of its cars to another car dealer and basically divest itself of all the cars on its lot, that sale would be out of the ordinary course of business and would require court approval. A sale in bankruptcy can either be public or private, and the distinction between being a public sale versus a private sale: a public sale is open to the public and pursuant to bidding procedures would be subject to auction and overbid, whereas a private sale would not be open to the public and would be to a specific buyer without the ability for others to submit overbids. Private sales are generally disfavored by the bankruptcy judges because without an auction, they really cannot determine that the sale price that's offered is the highest and best, and thus it's hard to check off the box that it's in the best interest of the estate. There are certain circumstances in which private sales are appropriate, and I think the most obvious one is where the sale price is at an amount that's going to pay all creditors, secured and unsecured, and administrative claims in full, and the equity holders who would benefit from any overbids have waived the requirement that the sale proceed through auction. These are just some of the basic predicates for getting a sale approved under 363. The sale has to be fair and reasonable, which includes a sound business justification, a sound and exercise of reasonable business judgment on behalf of the seller, trustee, or debtor in possession. There has to be good faith. The asset has to be marketed and for sale and sold at fair market value. And the sale needs to be free of collusion of any type. And look, at this, the ultimate ruling that the court must find with respect to a sale is that the sale is in the best interest of the bankruptcy estate, and that's the evidence that needs to be produced, and the new court needs to find that the evidence is sufficient to establish those three predicates. Again, under 363b1, there needs to be notice, and the court must approve the sale after notice. And notice is very important here, and it'll play into our discussion regarding successor liability and what types of claims can be avoided and barred. And that has been at the center of many of the decisions discussing claims that attempt to be asserted against the purchaser of the assets. So notice is an extremely important concept. The Bankruptcy Code just says that a notice of a sale needs to be served on all creditors, lien holders, and parties and interest, but I'll suggest to you throughout when we get to the successor liability issues that as the buyer's counsel, you should not just rely on the debtor's schedules and its list of potential parties and interests, but you really need to give some thought as to whether broader notice should be given. When you're representing an asset purchaser in a 363 sale, there's the basis of the sale is going to, just like a sale outside of bankruptcy, is going to be the asset purchase agreement, and that's negotiated between the seller and your client. If your client's going to be the stalking horse bidder, you negotiate that, and it's an exhibit to the motion to approve the sale, and you will have that asset purchase agreement incorporated by reference into your sale order and approved by the bankruptcy court. And again, once we get to the successor liability issues, you'll see that the form of and content of your asset purchase agreement is really critical to the types of claims that you can address and eliminate through the bankruptcy sale process. Again, while not at the crux of this webinar, just in general, there are bidding procedures that are approved, which require minimum requirements to participate in the auction, that include the minimum bids, deposit, evidence of financial wherewithal, evidence of disinterestedness, and as the stalking horse bidder, you can also negotiate and should negotiate for a breakup fee in the event that your client is outbid. You would get some reimbursement for taking the laboring or of drafting and negotiating the asset purchase agreement and establishing the floor price for the assets. Although we're not focused on it here in this case, in this webinar, the other way to accomplish a sale is through the implementation of a confirmed plan of reorganization. And there are two code sections in the bankruptcy code that provide for a sale under a confirmed plan. The first is 1123A5D, and the second is 1123B4. And in confirming, and again, while we're not focused on it here, plan confirmation is a difficult process, and going through all the requirements of confirming a Chapter 11 plan are beyond the scope of this webinar, but just focused on the sale issues. The sale itself doesn't require direct bankruptcy court approval or separate bankruptcy court approval. It's part of the plan, and the court must check off the boxes and determine that the rest of the plan is confirmable, including the sale component. But in practice, the court will look to see if the plan, it does include a sale of assets or substantially all of the assets. The court will look to the same types of factors in determining whether the sale is fair and reasonable, and whether it's been marketed and the price is fair. So I mentioned before that there are two ways to accomplish a sale in a bankruptcy, through a 363 and one through Chapter 11. On this slide, you'll just see the benefits and the differences between the two. And I think we can all agree that, boiling it down, a 363 sale by motion is faster and it's cheaper to effectuate. You can do a 363 motion and get a sale approved on regular notice in California on 24 days notice. You might have a slightly longer period if you're getting your bidding procedures and auction approved in a two-step process. but I think it's safe to say, and we've all seen them, you can get a sale approved right up at the beginning of a case within 30 to 45 days. And one of the cases that we'll talk about a little bit later, the Weinstein Company bankruptcy case, you had a sale approved and closed I think within 60 days of the bankruptcy filing, if not less. Whereas if you went through a Chapter 11 plan, you have a much more long, drawn-out process that includes the approval of a disclosure statement, dissemination of a disclosure statement, and and plan voting rights and confirmation rights. And I think that at quickest you would be looking at a 75 to 90-day process, and in many instances, a much longer process. So from a buyer's perspective, sitting around and waiting for the debtor to confirm a plan, it doesn't sound very attractive. And a lot of times you lose your buyer in the midst of a bogged down plan process, whereas a sale motion is much quicker and easier to effectuate. So we start getting into the free and clear issue. So that's at the center of this webinar. Under Section 363, a bankruptcy court can order, and it's particularly Section 363F, bankruptcy court can order a sale free of all liens, claims, and interests. And there are certain predicates, 363F1 through 5, which will be on the next slide, that authorize the court to sell free and clear of certain liens, claims, and interests. And in a plan, you're dealing not necessarily with the 363F findings, but you're dealing with the treatment of particular claims and interests that need to qualify under the appropriate plan confirmation rights. They also have voting rights, so you could go against 363 in a plan and have that lien or interest holder vote in favor of the plan, in which case you would satisfy their obligation. The way that you're protected, you don't get a 363 order out of a plan, but you would get a plan injunction, which can be very strong. In certain instances, it's suggested that a plan injunction under Section 1141D is actually stronger protection against future claims than a 363F order. While we've talked about in general what the benefits are, that this slide goes through some of the benefits of going through 363F sale. The main benefit, again, is the free and clear aspect. This allows you to transfer and acquire the assets, title to the assets that are being sold, free and clear of liens, claims, and interests. So in concept, once you acquire the assets, no creditor or party that had a claim against the debtor or against those assets can come after the acquirer for claims that existed prior to the sale. And here, as I said before, I think I said it was the next slide, but it was 2 slides from now. 363F provides the 5 scenarios under which a sale can be accomplished free and clear of liens. One is that the sale would be permitted under applicable non-bankruptcy law. Second, the party consents to the sale. Third, the selling price is higher than the aggregate value of all liens against the property. Fourth is that the lien is in bona fide dispute. And fifth is that the party could be compelled to accept a monetary satisfaction of its interest in a legal or equitable proceeding. So now that we have that background on a 363 sale and what the benefits are and how to accomplish it, I think it's in order to understand what we're dealing with in successor liability, it's important to go through and talk about successor liability issues outside of bankruptcy. What is it that we're trying to protect our clients, our buyers from within by going through this bankruptcy process? So successor liability is a legal theory by which claims asserted against a buyer of by which claims can be asserted against a buyer of assets of a business, even in the absence of an express agreement by the buyer to assume the liabilities. The default rule under California law is that a buyer of assets of a corporation does not assume the seller's liabilities. The exceptions are noted here, and these are based in common law and have been interpreted by courts and really form the basis that you'll see throughout the United States. But again, this is California. The exception is that the buyer expressly assumes them in the purchase agreement. That's not controversial. Second is that the transaction constitutes a de facto merger or consolidation between the purchaser of the assets and the seller. Because in a merger or consolidation, if it was an actual merger or consolidation, you would be picking up the liabilities of the seller. Third, the buyer is a mere extension of the seller. And fourth, the transaction amounts to a fraudulent or collusive attempt to avoid the seller's liabilities. In 1977, the Supreme Court of California in Ray versus Allad also imposed a fifth exception to the rule, and that is sometimes called the product line exception. We'll cover each one of the different 5 factors now. The de facto merger exception, in determining whether this was a de facto merger as opposed to an asset sale, the court looks to a number of factors. Was there continuity of the enterprise? Basically, did the business continue on as it was before with just a different owner? Was there a continuity of ownership? Are there the same parties on each side of the buyer and the seller? Did the seller cease to exist after the completion of the sale? And did the buyer assume certain critical or necessary obligations that were necessary to the continuation of the business and disregard others? With respect to the mere continuation exception, again, the court looks as, was there continuity of ownership? Was there continuity of management? Were the officers and directors the same on both sides? And was the consideration paid for the assets adequate or inadequate? And to me, as I read these types of factors that the courts use, and in particular this mere continuation, really sounds to me to be similar, and I think some of the bankruptcy lawyers would agree, sounds very similar to the concepts of fraudulent transfer law and the badges of fraud from which the court may infer that a sale or transfer of an asset was fraudulent and was designed to hinder, delay, and defraud creditors. I think we in litigating these things, you see those factors raised. The owners were the same. They were on both sides of the coin. They paid an inadequate amount for the assets. There was pending litigation at the time, and it just appears that they were trying to bust out the corporation. I think the most controversial one really is the one that has been law for the last 40 years, and that's the Ray versus Allred product line defense or product line exception. And this one really is grounded in and based in the strict liability under products, defects, and tort law. And like I said before, while these are California cases, this product line exception is recognized in many jurisdictions. Again, I haven't done a full survey to tell you whether it's in every jurisdiction, but suffice it to say that this product line exception comes up when you do research on successor liability throughout the United States. The court in that case, in my opinion, was really just trying to find a way to balance the hardships between the innocent buyer of a product and the company that bought the assets of a company that manufactured that and continued to manufacture that product. So in the Allad case, you had a client that was injured, or a plaintiff that was injured on a ladder that was manufactured by the seller, and the buyer, the corporation, continued to manufacture the ladder and continued to even use the name. And the court announced these 3 requirements for finding product line, for finding that the product line exception was applicable. The plaintiff's remedies against the original manufacturer must have been virtually destroyed as a result of the sale of the assets. The court's focusing here on, did the seller who originally manufactured the ladder or the product, is it now essentially judgment proof? Second, does the successor have the ability to assume the predecessor's risk and spreading role? The court in Allad didn't go through some financial analysis to determine whether the buyer had the wherewithal to respond to a judgment. It just assumed that by acquiring the assets and the manufacturing facility and the hard assets, that it had some ability to respond to a judgment. And then finally, it said it must be fair to require the successor to assume the responsibility because the successor continued to profit from the goodwill of the seller. And again, this all just seems to be a balancing test. And the fact that this is California, I think, a state which favors consumers, the Supreme Court created this law in favor of consumers and against the interests of buyers of assets. There are also, turning to the next slide, there are other types of liability for successors that you need to be concerned about. There's successor liability to government authorities, which include environmental issues, contributions to unemployment funds, training funds, disability funds, certain franchise and income taxes, and sales and use taxes that may carry with them successor liability issues to the extent that your client is found to be the successor under the law. So now that we understand or have an understanding of what the successor liability laws are in California and similar throughout the United States, we look to what can Section 363 and a plan do to bar those types of successor liability. And in considering what can and should be done, the courts are really attempt to balance overlapping policy considerations. In favor of the plaintiff, courts look to provide a forum for tort plaintiffs who purchase products before the bankruptcy sale to recover for their damages, and also consistent with that, to protect their due process rights. In favor of the buyer of the assets, the policy considerations are finality of the bankruptcy court order, which encourages buyers to pay more than if they were exposed to liability for pre-bankruptcy claims. And it also, you'll see some of the cases also focus on maintaining the bankruptcy priority scheme. In other words, if tort victims are able to recover from the buyer of the assets, why should, for example, ordinary trade creditors be left without recourse. And this is the issue. And going back to the Weinstein Company case, it was an interesting issue that came up during that case, and it is the disparity between sometimes those competing goals with respect to the bankruptcy priority scheme. In that case, which has quite some press, and I'm sure most of you are aware of it, there were victims, many victims of Mr. Weinstein's alleged sexual harassment, and some of those victims participated on the creditors committee in that case. And when the debtor filed the case, it filed with it a motion to approve a sale on a very fast timeline, and the sale was something to an outfit for something like $300 million. And at that $300 million, there was going to be a very small payout to the general unsecured creditors. Through the bidding process, there emerged another potential bidder, and that bidder bid slightly more than the stalking horse bidder, but mandated that $25 million of its purchase price be set aside for these tort victims, for these sexual harassment victims. And so you had these creditors on the creditors committee that were tort victims in an odd position. Do they support a sale that provides maybe on a pro rata basis more to the general unsecured creditors but with no victims fund? Or do they support the purchase price that would provide less to the general unsecured creditors but more for the victims because of the victim fund? And ultimately, I believe they recused themselves from the committee and voted in favor of the latter, which was disqualified as a bid for other reasons. So when in determining what type of claims are covered by the 363 sale order, some courts will look at the specific language of 363, which says that you can sell property free and clear of interests in the property, and liens, claims, and interest. But the focus really here is on interests. The word interest, and what does that cover? And that comes to a distinction between what's called in rem claims versus in personam claims. In rem claims are claims against the property itself, against the house, against the car, or against the piece of manufacturing equipment. And clearly, Section 363 says if you have an interest in that property or a claim against that property, it's covered by the 363 order. The fuzziness comes when you're talking about claims that are not against the property itself, but claims against the owner of the property that are then transferred to the buyer. And those are in personam claims. They're claims that arise out of the ownership of the asset, but not from the asset itself. And so in these circumstances, you have courts that are struggling, but leaning towards expanding the scope of the word interest to cover in personam claims. Particularly, you'll see it in the Second and Third Circuits. In the TWA case, for example, the court found that a 363 sale extinguished claims of certain flight attendants that were given flight vouchers in exchange for settlement of their pre-bankruptcy sexual harassment claims. The court found that the buyer of the assets, American Airlines, was free and clear of those voucher claims because the voucher claims and the sexual harassment came only as a result of the TWA's operation of the airline. Had it airline assets that were transferred, had it not had the airline assets to transfer, there would be no claims. So the court extended the scope of the 363 order and the definition of interest to cover in personam claims. And obviously, since we're in the Ninth Circuit, I've been looking for Ninth Circuit cases on this, and there aren't a whole lot, but you will find the decision in Stations Casino by Judge Seib in Nevada. It is a published decision that he follows the Third Circuit's precedent and the Second Circuit's precedent in the confirmation of a plan in which he held that the 363 allows sales free and clear of all personal injury claims, and he drew no distinction between in personam and in rem claims. Now, when you take a survey and start doing research regarding the scope of 363 and the types of claims that a 363 order and or a plan injunction will cover, notice issues become very important. One of the cases that's very recent in the Second Circuit in the GM Motors case, which is actually called Motors Liquidation Company, the court addressed the notice issue, and there are actually several decisions from the GM Motors case that deal with successor liability and the extent of successor liability. But this one in particular dealt with faulty ignition switches. And in that case, the court determined that notwithstanding what its order said, that its order did not cut off claims to owners of vehicles with faulty ignition switches because the debtor knew or should reasonably have known about the certain default ignition switches, and that the debtor should have provided direct mail notice to those plaintiffs in the bankruptcy case of the proposed sale. And while the court didn't rule that the outcome would have been any different had they received notice, it found that it may have been different because had they received notice, they could have had a seat at the negotiating table with the old GM, the seller, the new GM, the buyer, and some 15 other parties that participated in the sale. For example, the state attorneys generals participated in the sale and negotiated for trust funds to be set aside for lemon law claims. Ultimately, the court ruled that because no notice was given, the claimants could not be barred by the 363 order from bringing their claims. Once you have established that notice was given, a lot of courts do hang their decisions to bar claims on the fact that notice was given and there were no objections made. And that's, for example, in the Supreme Court held in the Travelers Insurance versus Bailey case that certain insurers were provided with notice of the order, and they were bound by, certain claimants for asbestos claims were enjoined from going against the debtor's insurers because the order exculpated those insurance. And the court said even without regard to whether the orders were proper exercise of bankruptcy court jurisdiction and power, they were barred by the order because they did not object. And I think some of us that are practicing in bankruptcy law also know that that 363 F2, which provides that sale and free and clear of interest can be approved as consent by silence. And courts are certainly split on the issue. There's a couple of cases that suggest that silence equals consent, where there are others that say silence does not equal consent. As we sort of get towards the end of this, I want to cover some cases in which, examples of which um, successor liability where the buyer was not protected from successor liability product defect cases. I think the most often cited one, if you do any amount of research on this, is a recent case coming out of New York called Grumman Olson. In this case, you would think, after going through this webinar, you would think that this would be protected, but the court reached a different conclusion. In this case, a buyer purchased a truck, or a buyer purchased a truck manufacturing division of the debtor. The 363 order was broad and purported to grant both in rem and in personam relief. A plaintiff was injured by a truck built by the debtor before the sale, but the injury occurred after the sale. The court then ruled that despite the broad exculpatory language in the order, it did not preclude the claim, and it really focused on a couple of things. One, because the plaintiff was not injured before the bankruptcy or the sale, he did not have a claim as defined by the bankruptcy code, so it couldn't be expunged. And second, because that plaintiff was not provided notice of the sale, and that notice was not even possible because he wasn't an identifiable party at the time of the sale. He hadn't been injured. He was deprived of due process and could not be barred by the sale order. In a case, again, going back to that Stations Casino case, this is an example where the buyer would be protected, although this is not a case where you have a creditor that is actually testing the exculpatory language. It's just Judge Zive blessing and seemingly unlimited release of future claims. And I think what was really interesting about Judge Zive's opinion there, in quoting under other cases, he said that state law successor liability theories are preempted by the bankruptcy code, which would give you some comfort if that were to be upheld on appeal, that what the bankruptcy court says preempts state law. Another example here is of the buyer being protected is in Delaware. Judge Walrath overruled a pension trustee's objection to a sale free and clear of an underfunding claim, and the trustee in that case was trying to argue that because the claims arose under ERISA and that ERISA is backed by an imposition of successor liability by statute, it should be exempted from the free and clear provisions of 363. The court rejected that and said there are other types of statutory successor liability claims, including sexual discrimination, and those claims under the Coal Industry Retiree Act that previous courts have held are subject to 363 and can be sold free and clear. And she also went to that rationale we talked about before. She didn't think it would be appropriate to elevate the claims of the plan trustee over the claims of the general unsecured creditors, and thus violating the priority scheme of the bankruptcy code. I want to have a brief discussion of environmental cases, environmental law cases. I think this is an area which is probably particularly interesting to a lot of us, since in California, many of our sales that are done through 363 involve real estate. And I'd venture to say that if you did a survey, you'd say that most of the sales that are approved through 363 involve the sale of real estate by percentage, as opposed to business or other personal property assets. There are certainly cases that go both ways on this issue. I have a couple of examples of them. Sorry, I skipped ahead. Where the courts have said that a sale order can protect a buyer from cleanup costs. And without going through these cases in particular, you have one or two in New Jersey where the court held that because there was a failure to object by the New Jersey Department Environmental Agency to a proposed sale, that that the claims for cleanup later were barred. And other courts have held that free and clear orders do not and cannot abrogate claims and obligations arising under CERCLA. And a couple of examples there. And the courts have held that CERCLA liability attaches the moment that the land is purchased. So as we get into practice tips, there's one in the bottom here. If you know or suspect that at the time of the purchase there is some contamination, or you suspect that there's some contamination, you should negotiate with the debtor and even consider bringing the appropriate state agencies to the negotiating table to address the issues and allocate the responsibilities. Because if you have their participation in the process, you're more safe with the with being protected by the order that comes out of that process. And some of the cases even talk about that as the reason for upholding the sale order was that the agencies did participate in the bankruptcy process. So I've been talking a lot for about 50 minutes, and I want to close with some practice tips. I think one thing that's clear coming out of this thing is that it's not clear. And unfortunately, that's not a great answer. But you can build into your sale order very broad provisions, and we'll get to some of them. An example of them, we don't need to go through them in detail. You can read them at your own leisure. But you can build in as much as you can, and you should, into both your asset purchase agreement and your sale agreement. But you need to advise your clients as a buyer that liability, successor liability, is still a potential issue. And in addition to conditioning your offer to the seller on the court's approval of very specific language with broad releases and exculpatory languages, findings that your buyer is not a successor, that the sale does not constitute a de facto merger, consideration was adequate, there was no collusion, you're not a mere continuation of the buyer, of the seller, etc., and condition the court's approval of the deal on your specific language, and give yourself an opt-out if the court is not willing to include any of that language. But ultimately, you need to take the remaining potential successor liability into account when you're pricing the asset and what your client's willing to pay for it. Additionally, don't assume, I don't think you know what happens when people assume that the debtor or the trustee will provide adequate notice, and that you should be involved in deciding who gets notice of the sale motion. And in particular, you should focus on potential claimants. If this is a product-heavy case, potential product liability claims, anything that's known or suspected, to the extent it's possible, economically feasible, there should be direct mailer or at least publication notice made regarding the sale, because this ultimately could be critical to the enforceability of your sale order as against future claimants. And then with respect to environmental issues, I recommend highly that you conduct your own phase 1 and phase 2 environmental studies. Don't necessarily rely on the debtor's study, particularly if it's outdated. Get in privity of contract with the engineer that's doing the study, and the only way to do so may be by conducting your own. And if there are environmental issues present or suspected, address them and do not rely on the sale order to be your shield. And one of the things that says as, but it should be asked for an assignment of any insurance policies that the debtor may have against environmental contamination as part of the sale, or buy a tail and negotiate that the debtor pay for that policy. We've been talking for about an hour, but I brought to as an example of a very well-written, very broad order approving a sale. And this is from the Weinstein Company case in Delaware. And this was entered, and you'll see the types of things that are included in this order include some of the things that we know based on this discussion, based on research, may not be enforceable at the end of the day. But they've thrown in the kitchen sink, and they have a bankruptcy judge to sign off on this, and they can certainly use this as a shield to the extent it's enforceable. But you'll see that they cover some of the things that we talked about, that there's a finding that the buyer's not a successor or a successor employee. It's not a de facto merger. It's not an alter ego or mere continuation. And then it's not any of those things within the meaning of any law, including ERISA, COBRA, WARN, CERCLA, FLSA, NLRB, or NLRA, sorry, and with respect to any environmental liabilities. And then I think that this is particularly interesting in this case because while we've seen a lot of this as rote language that you see in well-crafted orders, I don't know that I've ever seen Romanet number 4, that you're not a successor with respect to any liabilities under federal, state, or local laws or ordinances regarding sexual misconduct, non-consensual interactions, harassment, uninvited or unwelcome conduct. I'm just going down the list. Sexual assault, sexual misconduct, rape, intentional infliction of emotional distress, et cetera, et cetera, et cetera. And those are then defined as harassment claims. And then paragraph 22 basically says nobody can come after them for any of those claims at any time for any reason. And again, as you scroll through, you'll see that they cover environmental claims and they cover WARN Act claims and the harassment claims. So ultimately, we'll see. Maybe someone will test this. I don't think the order has been appealed, but maybe someone will test the scope of this in other orders. But the takeaway is draft it as broad as you can and as broad as you can get away with, and see what happens later. With that, I think I've covered my full hour. I really appreciate everybody's attendance. Again, to the extent that you have any questions, there's a button where you can send them to me, or you can reach out to me directly. I think most of you will have my email address, and I'd be happy to answer any questions at a later time. And we will also be reaching out directly to you with your MCLE certificates. And if you don't get them, ping me with an email, and we'll take care of it. With that, thanks, everybody, and I'm signing off.